Good afternoon. I'm Connie Simonelli, and I'm from the Commission on Human Relations. And I'm here to talk a little bit about what the Commission's doing to affirmatively further fair housing. So the work of the Commission involves working on diversity issues, working on reducing prejudice, discrimination in the city of Chicago, as well as enforcing two anti-discrimination ordinances, one of which is a fair housing ordinance. So we've got the Chicago Human Rights Ordinance, which, if someone believes they've been discriminated against in their employment or public accommodation, they have a right to file a complaint at our agency under the Chicago Human Rights Ordinance. If someone believes that they've been discriminated against in their housing, that would fall under the Chicago Fair Housing Ordinance. And then credit transaction and bonding discrimination, which are not very commonly filed, but we would take those complaints also under the Chicago Human Rights Ordinance. Now, fair housing is about ensuring that people decide where they get to live. Where somebody lives affects everything. It affects your transportation to get to work, the schools that your kids go to, the jobs that you can accept. And given the short supply of affordable housing, more than ever, we need to make sure that people are getting a fair chance at actually being able to decide where they get to live. Now, all levels of government have anti-discrimination laws, including fair housing laws. Each one of these agencies has different basic filing requirements. So for example, geographic limitations. In order to file a complaint at our agency under the Chicago Fair Housing Ordinance, the issue has to have occurred in the city of Chicago. If you file with the state of Illinois, the issue can have occurred anywhere within the state of Illinois. So someone may file a housing discrimination complaint with our agency, the Commission on Human Relations, the city's agency. Keep in mind that the same complaint or similar complaint can be filed at more than one agency. Now, our agency takes formal written complaints. Basic filing requirements, it has to have been, the alleged discrimination has to have been based on someone's protected class. It has to be filed within 180 days, and like I said before, the alleged discrimination has to have occurred within the city of Chicago. Who is a complaint filed against? It's filed against who controls the housing. That's if you have the ability to rent, lease an apartment, if you own the property, if you're managing the property, and the agents of those individuals, all of those people could have a discrimination complaint filed against them. Additionally, one of your employees or someone who you bring onto the property to do work could also involve you in a discrimination complaint. So who a complaint can be filed against is a large group of people. Be aware that unlike the landlord-tenant ordinance, there's no size requirement for the property. So for example, a two-flat, owner-occupied two-flat may be exempted from portions of the landlord-tenant ordinance, but not the Fair Housing Ordinance. If someone prevails in a housing discrimination complaint that's filed at the Commission, the remedies that are available to a complainant are out-of-pocket damages, emotional distress, punitive damages, as well as injunctive relief and attorney's fees. Additionally, the city can issue fines up to $1,000 per violation. So we currently have 15 protected classes. So we've got race, color, national origin, ancestry, religion, age. Age is defined as 40 years of age and older. Disability, sex, sexual orientation, gender identity, marital status, parental status, military status. Military discharge status was replaced with military status at the beginning of this year. Source of income, as it's noted above on the chart, is any lawful source of income. Additionally, something else that happened earlier this year is that retaliation was added as an additional protected class under the Chicago Fair Housing Ordinance. It's narrowly defined, so another agency may also have retaliation as a protected class, but each agency may define it a little differently. Our agency specifically defines retaliation narrowly in that it's retaliation for filing a complaint at the commission. So if somebody believes that they were denied housing or subjected to different terms and conditions in their housing, and they file a complaint with our agency and their situation gets worse, and they think that the property owner, the property manager took some sort of additional action against them, they can come back to our agency, file a retaliation complaint, and then that gets merged into that first complaint that they filed, and the investigator will add that to one other thing they have to investigate. So source of income means any lawful source of income. That's your voucher, that's your paycheck from employment, that's alimony, that's a trust fund, that's Social Security benefits. Be aware that an issue that comes up in housing discrimination, source of income cases is minimum income requirements. There's nothing wrong with having a minimum income requirement. However, be aware that if you apply anything more than the out-of-pocket portion of the voucher holder's rent, so the voucher holder has a portion of the rent that they may be responsible for paying, separate and apart from what someone else is helping with, right? How the other portion that's being subsidized. If you apply a minimum income requirement to anything more than what they're paying out of pocket, that has been found to be discriminatory. So if you have a minimum income requirement, be clear on how it is that you apply it. So these actions are prohibited discrimination in fair housing if based on an applicant or tenant's membership in a protected class. So failing to sell or rent, discriminatory notices or advertising, different terms and conditions, steering, blockbusting, panic peddling, termination of tenancy or ownership rights, harassment, sexual harassment, failure to accommodate either a disability or a religious practice is all discrimination if it's based on the individual's protected class. So steering is discouraging an applicant from renting in a particular neighborhood or building, exaggerating the drawbacks of a community or building, stating that an applicant would be uncomfortable in a particular neighborhood, or renting to voucher holders either all on one floor or one section of the building or one section of a development. In other words, isolating a protected class. Some specific scenarios of what steering looks like. Telling a voucher holder that they would be more comfortable in a building that the owner owns in a different neighborhood where there are many more voucher holders. Landlord, property owner, property manager doesn't need to give a housing seeker advice about where they need to live. Telling a voucher holder that they would not be comfortable in Lakeview because it's too far north and very congested. Telling a voucher holder that he owns a building on a west side neighborhood where applicant may fit in better. These are all examples of what steering sounds like. And again, it's also steering when an owner tells a voucher holder that he only rents apartments that are located on certain floors or certain sections of a development, and that the rest of the building or the other floors are for market rate tenants. Now, it's also discriminatory to refuse to rent to a non-voucher holder. There are examples of property owners who deny housing to non-voucher holders because they only want to rent to voucher holders. That too opens you up to a discrimination complaint. Additionally, it's an ordinance violation to refuse to make reasonable repairs or upgrades to non-voucher holders' apartments if you are making upgrades, repairs to the apartments of voucher holders in order to remain in compliance with CHA's inspection requirements. So what was being said earlier is the same thing that I'm saying now, which is you've got to treat your tenants the same, regardless of what their source of income is. Now, it's okay to apply a reasonable tenant selection criteria and tenancy rules as long as the property owner treats all applicants equally. So it's perfectly reasonable to have all applicants undergo a credit and background check. What's not okay is for you to inconsistently do a background and credit check. It's also okay to accept another qualified applicant who is ready to rent rather than holding an apartment that's unrented because a voucher holder's inspection hasn't happened yet. So you, as a property owner, as a property manager, do your due diligence. You process their application. You do all of those steps. You submit it, and now you're waiting for that CHA inspection. And in this case, several weeks have gone by, and you're waiting. The apartment's vacant. You're not collecting rent on it. Someone else expresses interest in submitting an application. Are you required to keep that apartment vacant until the CHA inspection occurs? You're not. The law does not require that. What we require, though, is that you process that application. So what's not okay is if you receive a voucher holder's application and you put it in the drawer and you wait 3 or 4 weeks, you keep receiving applications on that apartment, then you rent it out, the person files a complaint, and then you say, but it's rented. So do your due diligence. If a voucher holder submits an application, process it, do your part, and the rest is sort of out of your hands. You don't control how long an inspection scheduling will take. In the meantime, you have every right to continue to show that apartment and get it rented as soon as you're able to. So under the Chicago Fair Housing Ordinance, if necessary to fully use and enjoy a housing unit, a tenant with a disability may make reasonable modifications to the unit or the common areas of the building at the tenant's expense. So for example, if a tenant with a disability requires grab bars in the bathroom to safely be able to use the restroom, to use the shower, they have a right to have those installed at their expense. And a tenant with a disability may request reasonable accommodations to rules, policies, practices, amenities, or services. So if you have a no pets rule, you don't want any dogs, you don't want any cats, you don't want hamsters, you don't want any pets at all. If someone has a service animal or an emotional support animal, that no pet rule does not apply. Yes. You can ask for documentation from the physician, from their treating physician. You are not going to necessarily get a whole lot of specific information about what their condition is, but certainly you have a right to ask for a letter from the doctor signed, by a real medical doctor. Sure, you have a right to do that.
But until they get that, you shouldn't be in violation.
Correct. Right. Mm-hmm. Not if it, no. So if you have a no pet rule, or if you have a 25-pound pet rule or a 50-pound pet rule, if the animal is a service animal or an emotional support animal, those rules do not apply. You can't charge a deposit. You know, like a pet fee deposit? Nope, can't do that.
So, and you're saying too, you cannot deny a person that apartment because they have a pet,
An emotional support animal or service animal.
Discrimination.
Yes, right.
And you cannot charge an extra fee.
You cannot, no.
But as a homeowner, I don't have to rent to that individual. I can keep looking, right, if I want to see or check out other people.
If the reason that you're not giving them that apartment is because they have a service animal or an emotional support animal, that would be discriminatory. It would be discriminatory. It's not a pet. It's not a pet. What's important is that in these cases, when the applicant has a disability, when the tenant has a disability, because in some cases it's somebody who's already living in your property who then will inform you that they have a disability and they need to, they require a certain accommodation. What's important is that you be open to having that conversation. There's certain limitations as far as animals, but it's not always limited to a dog.
I have a tenant on my second floor, she's allergic to cats, so what, she's not a Section 8 tenant.
And,
They have a Section 8 tenant who want a bird boy, want a cat.
well, you mean any tenant that moves to the first floor that requires an accommodation? Are you saying you currently have a no pet rule?
Yeah.
You currently have a no pet rule. You have a tenant on the second floor who's allergic to cats. The air systems between these apartments separate,
Yeah.
so it may not be an issue.
Hairs.
So long story short, as long as they have a note from the doctor,
Right.
they can have a pet. It's to the discretion.
It wouldn't be a pet.
I mean, not a pet.
It's not in a pet.
Emotional support animal.
Emotional support animal or service animal.
Or service animal.
So the difference is a service animal is an animal that's actually been trained to perform a task. Emotional support animal is not as widely accepted, but under the Chicago Fair Housing Ordinance, an emotional support animal in housing needs to be allowed, unless it would cause an undue hardship. So for the gentleman who has a tenant who is allergic to cats, and we're hypothetically saying that a tenant moves in first floor and then informs you, oh, I have a disability, I need this accommodation, I need to have a sheepdog, very fluffy dog, right? And you say, I don't think I can do this. And so you're going to claim undue hardship. You're going to say, there's no way. My second floor tenant is going to, take legal action against me as a property owner for allowing this. How do you do that? So you claim undue hardship. You're going to have to present objective evidence of this undue hardship. You can't just say, my second floor tenant is allergic to cats. That's not enough. You're going to have to provide documentation showing that the second floor tenant is affected by that first floor tenant's living situation. So if the air systems are in fact separate, that's, it'll be something for you to research, think about, talk to everyone involved. And sometimes rather than saying, let me work really hard on figuring out how this is not possible, try working hard to figure out how do we make this work. Again, there is service animals and emotional support animals. It's different, but under the Fair Housing Ordinance, as housing providers, just be aware, pet rules do not apply to service animals or emotional support animals. Sexual harassment is any unwelcome sexual advances or requests for sexual favors or conduct of a sexual nature when submission to such conduct is made a term or condition of the tenant's housing, agreeing to or rejecting such conduct is used as the basis for a housing decision, or such conduct interferes with the tenant's housing. Requesting sex or personal contact in exchange for a rent-free tenancy or completion of repairs is sexual harassment. Filing eviction papers against or refusing to complete repairs for a tenant who refuses sexual advances is also sexual harassment. And be aware that a property owner, property manager may be held responsible for unwanted sexual advances made by a maintenance employee or other staff. National origin discrimination means discriminating against an applicant or tenant based on the place in which they or one of their ancestors was born. So the applicant may have the physical, cultural, or linguistic characteristics of a particular national origin group. For example, an individual who was born in Germany may exhibit linguistic characteristics of someone from Germany. The German-speaking applicant applies for an apartment. She does not speak English well, but she has good credit and she can pay the rent. However, the landlord rejects her rental application, claiming that he will not be able to communicate with her. This would be discrimination based on national origin. They may have a family member, they may have a friend, you may have a friend, you may have a family member. There may be a solution to being able to communicate better with them. But no, you can't deny somebody housing simply because their accent makes it difficult for you to understand them. So this is the Commission on Human Relations contact information. So one, we encourage property owners to stay informed about fair housing. Just this year, we had 2 protected classes. Well, we had 1 protected class added. We had 1 changed. So the ordinance does change. It gets updated. So stay informed about fair housing. Support the city in its efforts to affirmatively further fair housing in the city. The ordinance and the regs are available online. We can always mail a hard copy out as well if you call and ask. There's lots of other useful applications on the website, forms, handouts, flyers. A couple of things that we brought today. We brought our brochure, and we also brought the where to file a housing discrimination claim. So what that form gives you, that handout gives you, is the list of all the agencies where somebody can file a discrimination complaint at, the different protected classes, basic filing requirements. And remember, if someone files a complaint at our agency, it's possible that they'll file at more than one agency. So if you're the respondent, if you're the person who the complaint is filed against, you may be having to respond at more than one agency. Well, thank you very, very much for your time. And if you think of anything, I'll be around for a little while. Thank you.